Simon Power.
Put.
Now I'll take some more calls because this is the most substantive part of the bill. And
That's what they said about Part 2, Mr Chairman.
I wasn't here in Part 2. Oh, well. Well, I've had a look through it. It's quite a substantive part, and people are on task. No repetition. I call the Honourable David Parker.
Chairman, it's notable that the National Party has taken no calls this evening except for calls to call closures. There has not been one substantive contribution from the National Party on this, nor the Maori Party tonight. They're just trying to put this through. No, the Minister made an initial contribution, but there has been no contribution from any member on the opposite side of the House except for the Minister and the Chair. Mr Chairman, the last time I explained to the House why the Labor Party moved from preferring codification of the tests in legislation and dealt, I thought, with the issue that the attorney raised in his initial contribution. I want to now refer to two issues where there are problems with the statutory codification. The first is I don't understand why under Clause 60, Subclause 2, as set out in the supplementary order paper, but in this respect not much different from the form that was in the original bill, why there's no substantial interruption for exclusive use and occupation of a specified area by virtue of the fact of a resource consent for an activity being granted between the commencement of the Act and the effective date.
Yes,
now,
that's right.
That's a strange thing for me because what it almost implies is that if there was a resource consent granted outside of that period, it does undermine exclusive use and occupation since 1840. And so what is the case in respect of resource consents granted, for example, between the Ngāti Apa decision and the date of this bill? So that's one example where I think there is going to be a sense of injustice amongst Maoridom as to the effect of this. Another one where we've got problems is that the government early on decided that, well, they were going to stick with exclusive use and occupation. And then they decided, well, look, they could envisage times where there could be more than one party has a customary right that could have coexisted back in 1840. And so they came up with this concept that you could have more than one party having exclusive use and control. In effect, you could say that someone did it jointly, and so they thought, well, we need to accommodate that somehow. And they've got a mechanism in the bill that allows more than one party to come forward and to effectively have rights that customary title rights that overlap each other. And I have no problem with that. But what I have a problem with is they actually then come up and they say, well, if one person applies for a right, someone else has got to put up their hand at the same time. And if by the time they get through the process in respect of that first right, and they might have the second party involved, anyone else who was ignorant of the process or didn't at that time have the resource to pursue recognition of their extant right, if they don't put their hand up within that period, they've lost their right. And I can't see how that's fair. And I don't think a court would do that. I don't think a court would say, look, I'm sorry, you may have had rights, but because we've recognised somebody else's right, we're not going to recognise yours. You can have rights that can coexist. Why are we codifying this in a way that makes people lose their rights just because they didn't take part in the process? This is made even worse given the fact that some of these processes aren't going to be through court processes. I have great trust in the processes run by courts to protect the various interests involved, where there are competing private interests, and by that, and within those terms of, oh, look, here we go. We've got the National Party, here again crowing, why didn't we do this? Why didn't we do that in the last legislation? We did that because people like the man who's sitting next to you racked up race relations with Don Brash on Talkback Radio and brought out that racism in New Zealand that is oh so close to the surface whenever you scratch these issues. That's one of the reasons why we didn't get it perfect. And I would also say that although it was not perfect, it wasn't nearly as bad as has been characterised by critics of that particular legislation. We said, though, that there was an important impediment in the Act that we passed, and we acknowledged that we got that wrong, and that is that you should be able to get a court remedy. You should be able to get a court remedy. And you should get a court remedy if you had an extant interest that was not extinguished. Mr Chairman.
Paul, materia too, right?
Chair. The Green Party has a number of amendments on the table to this bill. See, just for those who maybe can't hear what's going on in the House, Tauhinare is very grumpy because his party won't let him speak on the legislation, because the National Party and the Māori Party want it to proceed very quickly. So instead of speaking and taking a call like other mature, responsible members of the Parliament who want to debate the issue, he is shouting at all of the members as they speak. It's a sad indictment on the way that the National Party and the Māori Party have whipped their members, such that there are people who are knowledgeable about the issue. Tauhinare was on the Select Committee, of course. He's not able to speak on it, and it is a real shame. It does lead to a great deal of shouting, which I'm sure members of the public can hear through their radios and televisions. However, the Green Party does have a number of amendments to the bill and would like to discuss those in a rational, mature way, as opposed to shouting a lot. They deal mostly with the tests, because this part of the legislation deals with the tests for customary marine title and for the protected customary rights. Now, these were in the Labour bill. They were territorial customary rights and customary rights, I think. So they're effectively the same two kinds of sets of rights that Labour had, but they just have a different name. One is the protected customary rights is the right to engage in activity on the land, and then the customary marine title is a greater set of rights based around the idea that the iwi might have had proper customary title determined by the court. So these are the two kinds of sets of rights in this part that Māori can access if they go to the courts, if they do their negotiations with government. And the amendments that the Green Party has put up to the first law is essentially to delete those tests. We don't believe that it is right for the government to set the tests for how Māori should be able to claim or prove either their customary rights or their customary title. It's our view, and has always been our view, that it is the courts who are the ones who should be setting those tests. And the reason for this is that the Crown has an interest in keeping the bar for those tests very, very high, because it's certainly the case under the Labour government, I guess, and under the national government. Governments tend to look first at their economic interests, at the retention of their political power, before they look at issues like justice and what is right. I think we've seen that with both kinds of governments we've had over this issue. And so the economic interest of government has been in keeping the ownership and control of the mineral resources of the marine and coastal area. And we saw that with last time when applications for mining came to a halt during the foreshore and seabed debate and deliberations, and then were ramped up massively after the bill was passed, when the Crown had acquired ownership of these areas for itself in legislation. Since then, there's been a great number of applications for marine and coastal mining in this area, and that continues. And again, in this bill here, we have the government doing the same thing, acquiring for itself using a legal fiction to make sure that it retains control of those areas. Now, that is one of the interests that has gone into the nature of these tests. How high should the bar be set for Māori to prove their customary title if it interferes then with government's economic interests? And then on the other side, there is the political considerations as well. So we don't believe that the government should be setting those tests because they have an interest in keeping that land for themselves for political and economic reasons. It is actually fairer and more just for the courts to determine these tests, in our view. The reason we consider that, and I know my colleague Catherine Delahunty spoke about this earlier, is that the courts will be able to, don't have those same political and economic interests, and courts never do, they don't do things perfectly either, and we've seen lots of examples of problems. But they also will have their primary concern, at least structurally, is the stability of justice, making sure that justice is met. And they will also have the ability to look at wider than the government is prepared to do. And one of those areas, for example, is looking at the history of colonisation in this country. The Waitangi Tribunal reports that have set out year after year after year how land has been unlawfully taken by the Crown, utilised, structures built on it, things done to it, kept out of Māori hands despite continual... Mr Chair.